Morning. My name is Tanner Downing, and I'm the civil rights advocate and litigator from Washington, D.C. that Ms. Saxon was just talking about. I want to step up here, provide a little bit of clarification to you guys so that you can understand what was just said, what we're actually asking from you, because that's extremely important. Please don't neglect the information I'm about to give to you because it's extremely important, okay? I'm not trying to get anybody in trouble. That's not what this is about. We're here to provide information to you guys as the legislative body, letting you know that agents of this state and county are acting unconstitutionally and that the budget that you guys prepare is actually paying for that work to be done. That doesn't mitigate your culpability within the criminal action, the criminal conspiracy. It actually enjoins you because you guys are preparing that budget. It doesn't matter if it's willful, negligent, knowingly, or not knowingly. If you pay people to abridge their constitutional obligations, that is a crime. So I have approximately 14,000 criminal affidavits on behalf of victims that have been charged by way of information as opposed to indictment from right here within the state of Nebraska. Many of them are obviously from within Lancaster County. And so these affidavits, again, no state can create its own alternative legislation, substitute that for the guarantees of the Constitution, and go out and enforce that as though that's constitutional. But the state of Nebraska has done just that. The state of Nebraska has decided that they are able to determine whether or not a person is going to be charged by way of indictment or information by discretion of the prosecuting attorney or the law enforcement officer. You can never use discretion with regard to one's constitutional obligations. Obligations must be performed. Otherwise, you're abusing your discretion to break the law, right? This is a very simple concept. So if your sheriff's department are going out and executing a warrant that's based upon a judge who relied upon a prosecutor who abused their power by relying upon an inferior state statute that permitted them or directed them to charge by way of information as opposed to indictment, violating the Constitution of the United States, that sheriff is committing a crime. When that sheriff arrests that person, takes them into county jail, who you guys pay the budget for, prepare the budget for, and they house them there, that housing is unconstitutional because it derives from that unconstitutional act. So these affidavits, they identify two different crimes in particular. The first is Title 18 U.S.C. subsection 242, which is deprivation of rights under color of law. What that statute says is that any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution commits that crime. Now, the second crime is Title 18 U.S.C. subsection 241, which is conspiracy to deprive of rights. What that states is that when two or more persons conspire with the purpose of depriving any person of any right secured by the Constitution commits that crime. Now, the law is a criminal conspiracy with regard to public officials, all of you. What that states is that any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of the commission of the same, neglects or refuses to do so, may be joined to dispense the action. So upon having been provided with this notice, letting you know that these unconstitutional acts are happening, I'd ask you, please, let's work together to fix this problem, right? Let's work together to fix this problem. Because the alternative is that we will have to start converting these criminal affidavits into criminal complaints. I don't want to have to head down that path. You guys don't want me to head down that path. Please don't make me have to do that, right? We can work together to fix this problem, right? We can. But it's going to require you guys stepping forward in truth and then working to correct the unlawful acts of those agents that you guys prepare the budget and pay the work for. That's the power that you have as the legislative body here. That's what we're actually asking from all of you. All right, so I know that you're going to go to your attorney. And you're going to ask your attorney, since we're done, whether or not what I'm saying is true. And that attorney is going to point you to a case from 1884 called Hurtado versus California. And before you choose to rely upon that as the foundation, I must remind you that the Constitution of the United States of America is the foundation, not a judge-made ruling. The judicial branch has no constituted authority to be able to alter, amend, or destroy any of the provisions that guarantees the Constitution, because that must be done by an authentic act of people in accordance with the special amending procedure of Article 5. Furthermore, judges cannot legislate. We know that because Clause 1, Article 1 says all legislative powers vested in the Congress of the United States. So do not rely upon the belief or the misunderstanding that the judicial branch is able to amend the Constitution of the United States. So I pray that you guys are going to make the right decision here, right? I know it's a very difficult decision because as soon as we're done here, you're going to have to decide whether you're going to rely upon a judge-made ruling as the foundation and follow it, or the Constitution of the United States of America, the object to which your fidelity is bound. But I pray that you'll make the right decision. But just to leave you with this, all right, because I want to entice you guys in the right direction. The United States Circuit Court has identified a two-part test to determine abuse of discretion. The second part of that test says that any erroneous view of the law is an automatic abuse of discretion. An erroneous view of law would be that in your legal contemplation, the lowest form of law, judge-made ruling, is superior to the Constitution of the United States of America. That would be an obvious erroneous view of law. Therefore, if you continue to pay these public officials, then an automatic abuse of discretion will have occurred. Thank you guys so much. God bless and have a great rest of your day.